right, I'm going to start. Good evening. My name is Kit Needham. I'm Associate Director with the Center for Innovation and Entrepreneurship and the Entrepreneur in Residence for Project Olympus, the startup incubator here at CMU. Welcome to our second Start Smart. This is a series of free legal seminars that we do in cooperation with the University of Pittsburgh Innovation Practice Institute at the School of Law. Here is my partner in crime, Stephanie Dangle. And together with David Lehman, we identify a series of free legal seminars that are on topics that are relevant to startups throughout the year. So welcome. This is the second one. The other one we had not too long ago was on contracts. So we also have somebody else new joining us too, and this is our Silicon Valley campus. So Silicon Valley, wave hello. Let me know if you're there. Yeah. So can you just real quickly kind of go around the table and tell us who you are?
Sure, Kit. Thanks. I'm Gladys Mercier. I'm the director of the software management program here, and we have some students with us.
I'm Bruno. I'm a student for software management.
I'm John. I'm a student from software management.
I'm Isabel, and I am part of the Venture Bridge.
Venture Bridge, yeah. Okay, so and which team in Venture Bridge are you with?
Cappuccino Interactive.
Okay.
So we're working on marketing.
That's a new team for this semester. Excellent. So we thought we'd have a few more, but apparently there's a class that's happening right now, and we're not a gigantic campus, so this is it.
Okay. So I have to say we're pretty much at a full house here in this room. We're very grateful that we were able to do this televised presentation. I got a little late to getting David's presentation, so tomorrow it will be up on the website under the cmu.edu/CIE. You'll see workshop materials, and you'll see this presentation. So you don't have to take detailed notes of every word in there. It'll be in the slides. Oh, it is up there already. You must have. Okay.
Make sure it's this year's.
Make sure it's the current one, because sometimes we have them from less. Okay. This is magic then. I kind of like that. So one of the things that we do at every one of our connects, we call them connects for a reason, is that we try to match up people who are looking for talent, teams are looking for talent, and talent that are looking to join teams. And those of you who have been before, you know it's a really quick, hi, my name is such and such, here's what I'm doing, or here's my background, and this is what I'm looking for, and then you conclude by saying your name again. And I have to tell you already, I have had now people who have found each other through this process show up at Olympus saying, we found each other at a Connect, and now we're working together on this project. So I'm going to encourage everybody to pop up and say it. I'm going to start out with just one or two. We're going to do it at the end again for anybody who either was a little shy or hadn't thought about what they wanted to say. You can also ask for something. Let us just say that you're looking for a contact in a certain industry, a certain company. You're looking for somebody who has some domain expertise. So it could be you're looking for help as well. So we're all reaching out to the various communities. So let me ask you, how many law students are here tonight? Okay, we have a handful, which is really good. How many are from Pitt? Nice, welcome. Glad to see you here. How many of you are from another university besides CMU? I'm getting to the Portugal team. So CMU, we partner with Portugal, and we bring over 4 teams from 8 people that come over and work in our space for 6 weeks during the fall each year. And so they've been very faithful attendees at a number of our connects. So let me ask you real quick, do we have any who have a quick ask that want to do the connects? Okay. Yeah. I don't know if that works.
Okay. At the bottom of it. Does it work? Okay, you're listening?
Okay.
Okay, I'm one of the teams in CMU Portugal. Our company is called PlaySketch, and what we do is mobile apps that allow anyone to create their own simple games through drawings on a paper. So we're here also to help us validate our products, perform some markets, some product market fits, And right now we're looking for people that work in the area of marketing or that have some experience with mobile apps or gaming, so we're interested in that. And also companies that operate on that space, so we can perhaps connect with them and learn something with them. So that's my
Okay.
pitch.
And my name is Mario, and I'm with Play Sketch, okay? Always say your name at the beginning and at the end, because people don't know whether they care until after they hear what you have to say. So anybody else? So nicely done, Mario. Oh, did I do that? I'm sorry. Federico. No, okay. No, got it wrong again. All right. Usually Pedro's safe, but.
Okay. So, yeah, my name is Pedro, not Mario.
Yeah, I know. I'm sorry. I actually know better. Okay. Anybody else? Yeah, put button.
Yeah, the green button at the base. If you speak into it, then our people in Silicon Valley can hear.
Hello?
Okay, that's
Okay,
better.
good. Okay, my name is Francisco. I'm with Celix. We've developed a software that allows 3D game developers to create 3D scenes in a more efficient and manageable way. If anyone knows, people, 3D game developers, contact us. My name is Francisco from Celix.
Okay. Any others before we start the main presentation?
If you want.
Okay. So we'll do this right at the end. We'll just see if people have gotten inspired or remembered something that they're looking for. So I'd like to introduce to you now David Lehman, who is an attorney at K&L Gates, and he is probably the top startup lawyer in town. He did not pay me to say that. I've just heard this from other people. And we are very grateful for him for spending his time, donating it to giving these presentations and advising a number of our startups. So I'm turning it over to David.
Yep, I think so. Stephanie, did you want to say a few words about the IPI before I get started? Yeah.
This is Stephanie Dango. I'm Executive Director of the Innovation Practice Institute at Pitt Law School. We partner with Project Olympus. We train law students to work with innovators and entrepreneurs and to be more innovative and entrepreneurial themselves. So we're really excited about working with the Silicon Valley campus and hope that there's some way that we can connect in the future. Thank you.
Well, that was awfully quick. So, first of all, can everybody hear me? Oh, that's good. This thing's actually working. Well, thank you for those very kind words in the introduction, and a couple preliminary comments before we get started. And the principal one is that it would be great if you ask questions along the way, both from the Silicon Valley campus and here in Pittsburgh, because if I just sit here and ramble for the next hour and 21 minutes, this is going to be extraordinarily boring. So if you could, feel free to ask questions, take me off in different directions. If we go too far off, I'll bring us back. But you should feel absolutely free to interrupt me, yell, scream, whatever it is you want to do. And so we'll do that. And I must say, I've mentioned this before. It's an honor to be here because, as you may or may not know, I'm sort of the hybrid of both. Because I went to CMU more years ago than you can possibly imagine, and then I went to Pitt Law School. So, as I like to say, for those of you in Pittsburgh, I'm just working my way down Forbes. And if the 61C doesn't go there, I don't go there either. So what we're going to do is talk today a little bit about startup companies and raising capital for them. And you'll see the title, Avoiding the Pitfalls. That's pretty easy. And so we'll talk about some of the legal pitfalls associated with raising capital for startup companies and the important part. And I add another one, positioning the company for it, which is trying to set up the company, at least from a legal perspective, in a way that which will facilitate raising capital. And so that's really the emphasis of this talk. We'll do an introduction, which I just did. We'll talk a little bit about the challenges of raising capital and what it is you need to think about when we do the structure. I will act like lawyer for a moment. We'll talk about the applicable laws, what it is that one has to worry about, the securities laws, and how one complies. I'll try to get through that as fast as I can, in part because the lawyers have already heard it and the business people don't want to hear it. And we'll talk about the security. When you raise capital, what is it you should give to people? Should be a common stock, preferred stock, convertible debt, common debt, straight debt. And we'll talk a little bit about each one, the benefits, cost of each one, valuation associated with it, and that sort of thing. We'll talk about some of the commonly discussed terms. Control. How much control of the company do you have to give people? What do you about anti-dilution protection? That kind of thing. So we'll talk a little bit about that. We'll talk about the top 10 pitfalls or so, because I can't hold it to 10, the biggest mistakes I see. And then questions and answers, but let me emphasize again, don't wait. Feel free to interrupt me along the way. Okay? Anything somebody wants me to cover that I didn't mention? Moving on. So one of the when one raises capital and thinks about a growing company, growth company, and taking some money, I like to think about these competing interests because you're going to, and it's pretty good to bear this. If there's any slide you walk away from, I'd like this to be it. And you think about this going forward. Because when you put it together, these are the competing interests. Obviously, you have the founders. That would be, in many cases, you folks. And you really have two hats on. The contributions you're making today, right? And does I have a question over there? Did I? No. Okay. What you're contributing today, and you ought to get paid for that, and your ongoing contributions. Talent management. We want to pay people and give them equity going forward to incent them to grow the company going forward. We're going to license technology, ideas, concepts. Those have to get licensed in, and we've got to give equity for those. So when you license from the university and you license the technology out, not only are you going to pay a royalty, but we're going to give the university some equity. So in many cases, we've got to compensate and give people equity for the technology. And of course, there's the cash. Oh yeah, the cash. And we got to pay them for that. And I'm going to break the world in two parts for that too: current capital and former capital. And we'll come back to that in a moment. So when we bring in money, we got to balance all those competing interests. And I'm emphasizing this now because I've seen this more in the last couple of years, be a problem more in the last couple of years than I had envisioned, actually. And I'll give you two examples. One is on the first one, compensating talent. You want to make sure you have enough equity in your option pool, et cetera, retained to attract talent and maintain talent. Make sure they got options and things like that. I recently had a case in which it's really funny because there were two founders, and believe it or not, they had a dispute. That's shocking, isn't it? Never happens. Told them it was going to happen, didn't happen. They said, no, can't happen. Sure enough, two founders, 50% had the infamous dispute. And then we had an equity plan on top of that. But the real problem was, one of the founders left but owned 50%, or maybe 40% because we diluted it for the option pool. Now I have somebody who has no ongoing interest in the business, not going to contribute to the value, but owns 40% of the business. That's a problem because I'm going to have trouble attracting capital to this company because 40% is owned by somebody who's really not going to contribute to it going forward, either capital or otherwise. We ended up, what's interesting is her brother actually owned 7%. We bought out her 40%. We were just negotiating with, that's top of my mind, because we were just negotiating with venture capitalists this week, and they were whining about the 7% that the brother has, but we bought out the sister who had 40%. So I explained to her that sort of the venture capitalist is a glass half full versus glass half empty thing. He's worrying about the 7%. I was worried about the 40%. So this is a very minor problem compared to that. But the point is, when venture capitalists, new money comes in, they're going to be worried about equity going to people who are no longer contributing. And my other point was on the last one about the capital, even new money doesn't have a huge amount of respect for old money. They want to know who's contributing in the future. So part of when we think about the capital structure going forward, you want to make sure you leave room for growth for employees, the founder, and room for additional capital, because that will be the funding to fuel the company going forward. And we'll talk a little bit about those themes as we go through this. And I'll put a little more meat on it. So we don't need to do the agenda again, so we'll go to, and another threshold matter that I'd like to spend a moment on, which is people jump right into, well, here's how it goes. I have an idea. I license it from the university. I go to one of the incubators. I get some money. I go to the angels. I get some money. I go to the venture capitalists. I get some money. And then I go from that. And I want to stop before you go down that road and say, okay, are there alternative sources of capital that are non-dilutive, that I don't have to give a part of the pie in order to get money? And it turns out there are some. Now, not in every case, and it doesn't work every situation, but before you go raise capital, somebody should stop and think to themselves, is this the best way to capitalize this company? Non-dilutive capital is much better. I don't have to give up part of the pie. So here are some others, and let me give a couple examples. There you go. There's a concept, customers. Get customers to pay for it. So as an example, we have one client who had basically licensed the business, licensed it and does trials, and basically does tests for the customers, which they pay for. They've developed the technology on the customer's nickel. They make sure the company owns the technology, and they license it to other people. So they're using license fees or customers' down payments or other things, money from customers to pay for it. That's a choice. At least think about it. Is there a way to get upfront fees or royalties or something from customers to pay for it, beta tests or otherwise? Bootstrapping. There's a word. Is there a way to start getting revenue early? Some businesses, for example, are originally a consulting business and convert to a software business later. Can I sell consulting services as a means to gain capital to switch to a software business? So I'm not suggesting that everybody should be a consulting business. That doesn't have great upside to it. It's fun, but it doesn't have the same upside or multiples. But on the other hand, maybe it's a way to generate immediate revenue. License fees I talked about. Public financing, there's lots of public financing out there, whether it comes with some strings, but at least it's worth thinking about. Are there grants to get? SBIR grants, other kinds of grants. Think about whether that's out there. Yes, borrow money. They can borrow money. Is it possible to borrow money from other people? Now, that comes with collateral, and we'll talk a little bit about that, but maybe there's a way to borrow. Sometimes people get money from their, we have one client who just took a round of financing from one of their vendors, who gave them debt on a very low interest basis because they want to continue being their sole vendor on that. So for an exclusive vending arrangement, they gave them some pretty good terms for financing. And of course, crowdfunding, which we'll spend a moment on in a moment. So before you go and raise money from third parties, my point is think about non-dilutive capital. Now, assuming that you don't go to the non-dilutive capital, then here's the sort of series of the funding cycle that I typically see. And usually before you get to the public markets, more companies than not are ultimately sold. But here's the way. And we're going to focus here principally on friends and family, early angels, and early venture capital. It's sort of the rounds that we're basically talking about. But typically people go to incubators in the first instance. Then they go to the public agencies, and then friends and family and venture capital, angels and venture capitalists. And I don't know if people know what angels are. There's a short of venture capitalists. These are people who basically have more money than they know what to do with, and so they there's a look. But people who are experienced business people, typically, who have a nice portfolio and willing to take a part of that portfolio and invest it in what tend to be fairly speculative but high upside investments. One thing occurs to me, by the way, the other caveat I should have given you is that I tend to represent more of the companies than the venture capitalists, so you will find disparaging comments about the VCs all the way through my discussion. And you should understand that's my thing, because what I do is I negotiate against them, and I look for ways they're going to treat the companies not very well. So you'll hear a little bit of that orientation here, and hopefully there are no venture capitalists in the room. Anyways, when you take money from people, you are regulated by the government. Sorry, it's just a fact. And not only that, there's federal and state. We'll talk about the state in the moment. Right now, I'm going to talk about the Securities Act of 1933. And sorry, I know you just can't believe that we're going to talk about the Securities Act of 1933 in connection with raising a couple $100,000 or something from folks, but that just is the case. Every time you sell a security, you are subject to the Securities Act of 1933, believe it or not. And in theory, a security is broadly defined as anything that is an investment vehicle, and investment vehicle is pretty much anything that somebody gives you money and expects some upside for it, except maybe short-term debt, but otherwise it's a security. Okay? And as a general matter, absent an exemption, one has to register the sale of a security. And a registration is really filing an S1 with the Securities and Exchange Commission, that big thick thing that costs, I love it when people do this because it costs them, legal fees of upwards of $1 million, and it's a big deal. You got to go through the review process and everything else. We don't want to do that, right? So in your world, until we get to the IPO, your sole objective in the Securities Act of 1933 is to avoid the Securities Act of 1933 and find an exemption. And that's the whole game that we're going to spend the next 5 minutes talking about. And there are exemptions for this. And there's a couple right there. You don't really care. Through Section 3B and Section 4A2, you don't need to know that. You just need to know there are some small issuer exemptions that we're going to talk about. But let me talk about what it's an exemption from and what it's not. It's an exemption from the registration process I just described. So you don't have to go and file the big S1 and all that stuff with the SEC. But what you do have to do is give a notice to the SEC on what's called a Form D. So you will have to give a notice, and if you don't, you have not properly been under the exemption. And two is it doesn't take you out from under the fraud provisions of the Securities Act. So you're still liable to people if you, here it comes, don't make a material misstatement or omit to make a tell them a material fact. We'll talk a little bit about that. So you got to make sure we still disclose information to people, don't defraud them. That's common sense. And also, you still have to worry about filing with the SEC. So there's something called the Regulation D, and that's the exemption that everyone who starts a company in the beginning will use, Reg D. And Reg D is a safe harbor out of the Securities Act of 1933. And there's a couple different parts of that. The one that we've always traditionally used and you will likely use is Rule 506B. Used to be 506, now it's 506B. And what it says is you can sell up to 35 accredited investors, and I'll define that in a moment, and as many unaccredited investors as you can. But if you sell to unaccredited investors, there's a heightened amount of disclosure you have to give to them, including financial statements that you probably won't have. So my advice is only sell to accredited investors, but we'll come back to that, but that's for a different day. And you have to have a reasonable belief that people are accredited investors, and a reasonable belief means that they fill a little piece of paper out that says they're an accredited investor. What's an accredited investor? There's the definition there, but the important thing for you is that it has to be somebody who has either a net worth, excluding their house, of $1 million. I think it's excluding, right? Yeah, excluding the residence of $1 million. That's new, which is why I have to check. Or income in the last 2 years, and expect to have this year, of $200,000 for an individual, or if you're married, $300,000. So if they're an accredited investor, then you're under Rule 506B, and we're ready to go. Okay. The definition, this is probably, you should know, probably don't care, but the definition of accredited investor will likely change and go up. That's one of there's a lot of tension right now. We see the Jobs Act and et cetera, we'll talk for a moment about, and there's a tension between allowing more people to buy more securities and without interference with the SEC against protecting people. And so the definition of accredited investor is old. It's likely to change. There's some numbers. With inflation, when it was first done, that's what it would be today. So I suspect that it will go up, but for the moment, the definition I gave you is the current definition. So common requirements for the exemption, and this is really important. For the one we just talked about, there can be no general solicitation. I'm going to talk about when you can do a general solicitation, but under 506B, for what we just talked about, you cannot do a general solicitation. General solicitation is defined as things like on the website, putting on your website, hey, I'm looking for for money, right? And so send me money. The minute you send that on your website, you're out of 506B. You don't have that. You don't have that exemption. Sending out flyers to everybody you know, that's a general solicitation. Don't do it. So that will take you out of exemption, and so you can't do that. And the others are the reasonable belief that the purchaser's buying it without an obligation intent to resell. That you'll just put that in the subscription agreement, so that's probably not a big deal. And you got to file your Form D that I mentioned earlier with the feds. Yes.
I don't know if that's working. What about AngelList? So like sites like AngelList where you can connect with angels, they typically they have an accreditation process for their investors, so is that allowed, I guess?
So the question about AngelList and how that works. An AngelList is interesting. The way that works, I don't know if anybody's gone on the website, but that's a site in which you can register and sell to groups of potential investors, and you put your business plan on there, et cetera. The people that are on there are already accredited investors, and by virtue of the registration process onto there, it's been determined by the SEC that they are not. It's not a general solicitation because they've already gone through a registration process. So they've gotten around this by virtue of it not being a public offering, not being a general solicitation, having accredited investors, and therefore it falls under the exemption I just talked about. And that's how they get around it. Other questions? Yes?
When you say general solicitations, does it have to be something in writing, or if you stand up in front of a group of people with potential investors and sort of pitch your company, can you get it into trouble by sort of using that as a general solicitation?
So, yeah, the question is, if you get up in front of a group of people and it's not in writing, and you get up and say, and you pitch your idea and there's an audience, is that a general solicitation? And that's a good question. And first of all, I'm not sure that I would make a distinction between writing or oral. I think they're the same. So that's not the distinction. I think the distinction that people feel comfortable with is most of the time when you do those kinds of presentations, the people that come into the room are sort of pre-registered. They're people that have signed up beforehand. They typically have some kind of they're pre-registered. They're probably pre-qualified, and therefore the view is it's not really a general solicitation. If you're that's generally the answer. So it's used. Pardon?
Demo days.
Yeah. So I guess the other demo days, I get it. I think what most people do is take the view that you're doing so little on the demo day, they probably aren't even doing a general solicitation offering securities in that because you're doing so superficially that you're not even offering it. But I think people are blinking at it at the end of the day. I think at the end of the day, as a technical matter, if people are getting up in front of demo day and there's no real pre-registration and people are just getting up and talking, and I think one could take the view that it's a general solicitation, but I think people just generally ignore it. Yep, I think people just ignore it. Yes, question?
Yeah, okay.
Excuse me.
With regards to you mentioning how it can't be for resale purposes, is there a typical way that that's prevented, like an agreement upon purchase that it can't be resold for X years, or representation on a board of some kind?
So the question is there, how do you evidence the intent not to resell? And typically when you acquire a security, you sign what's called a subscription agreement in which you agree to purchase it, and you make all kinds of representations you make representations, there's been no representations to you, and you've been told everything about it and all that stuff. But one of the paragraphs in that subscription agreement is always you do not intend to resell the security for at least a year. And so the way the company protects itself is the purchaser makes a representation to the company that they don't intend to resell. In addition, there's typically a restriction on resale. So the company also says you can't resell it for at least a year without the company's consent. So it's both you're making a representation and you're contractually obligated. Okay? Answer. Other questions? Excuse me, got a little cold here. I don't want to be the cough in your ears. Let's see, where were we? So you've heard a lot about the Jobs Act, and and we're going to touch on it in a couple different ways. One of the ways that it impacts very early stage startup companies, it amended Reg D that we're talking about, and it created a new rule called 506C. And the intent of this is to allow people to make, to engage in the general solicitation. In other words, if you decide you're going to use Rule 506C, you can actually do general solicitations. You don't have to worry about the demo days. You don't have to worry about what's on your website. You don't have to worry about that sort of thing. You can do whatever you want. The caveat is, there's the quid pro quo is, every single purchaser must be an accredited investor. And remember when I said all you have to do is, for 506B, all you have to do is have somebody fill out a little form? This, you have to go much further. You have to know that they're accredited investors. And there's some criteria to do it. And here's some, here's some of the ways to do it. You have to get to look at either their IRS forms, you have to get an accountant to verify it, you have to look at bank statements. I mean, there's a whole list of them. But from your perspective, you have to know before you do the general solicitation that you're only going to sell to accredited investors, and you have to be willing to undertake to know that they're accredited investors, to do the due diligence necessary. So part of the point behind this is that in order to qualify for 506, you're going to have to make a decision early on, and so I'm going to make this point because I want to make sure I emphasize it. Either you're going to go the general solicitation route, or you're not going to go the general solicitation route. And it's really important to decide which one you're going to do, because, and the point I want to make is that I don't want people to do it inadvertently. So I don't want you to have to go one way or the other. Okay? Yeah, I don't give a little on. I talked about this federal compliance. Okay, it's actually, this is pretty straightforward for startup companies. We don't have to go much further into it than that. But you also need to know, unfortunately, there's also state. Every state in which you make an offer, you have to comply with that state and sale, which is just remarkable, but that's the case. Here's the good news. The good news is that in most states, under Rule 506, it's preempted. And so if you comply with Rule 506, in the state, you don't have to do a separate registration process, but you do have to still file a form there, okay, for most states. And why? Because you've got to pay a filing fee. And why do they like that? Because that's how the states make money. So you have to, every time you go into a new state where you're going to offer security, so if your cousin says, I want to invest in your new company, and cousin's in Texas, you've got to check Texas law and make sure you comply with Texas rules. And there are some states that are really worse, as in New York. New York is a pre-offer state, which is to say you have to actually register in New York before you make an offer. That's different than almost any other state. So again, before you start doing this, you need to talk to a lawyer to make sure you complied with each state's laws. And again, the state where you make the offer is not necessarily the state of the company. So if I'm a Pennsylvania corporation and I'm making an offer in Nevada, I've got to make sure I comply both with Pennsylvania and Nevada law.
David, I have a question.
Question?
So I have 5 accredited investors, and 4 of them are from Pennsylvania, but 1 of them is from New York.
Yep.
So I have to actually file just to get the money from that New York investor?
I have to file in New York to get the money from the New York investor.
Right.
Yes.
I do.
Yes.
Okay. Thank you.
Yep. But I have to not only do that, I have to file in New York before I make an offer to the New York investor. Okay, which is right. So even before you send, for example, if you have a private placement memorandum, I got to send that to him before we go. Yes.
What about angel groups in other states?
Same thing. Pardon? Oh, I'm sorry. So what about angel groups? And same thing. If there's an angel group in another state, I got to worry about the same issue. Question.
What if you haven't made an offer, but you're approached by an investor in another state?
So the question is, what happens if you haven't made an offer, but you're approached by an investor in another state? Most states, it's really based upon sales, so I'm not too worried about it. But before you make the sale, well, let me do it this way. First of all, New York, putting New York aside, I'm worried about the sale. So if somebody approaches you before you make the sale in that state, be sure to check the law and make sure you comply. I'd want to file before we close on the money. New York, if somebody approaches you, I would take the view that I've not made an offer in New York, and therefore, before I send them materials, again, you got to check the file in New York. Okay? Yes?
Is there any other hot states to avoid other than New York?
So the question was, are there any other hot states other than New York to avoid? And you mean for securities purposes? There's plenty of states I'd avoid just generally, but that's not what your question. It's a different question. I think I'd worry a little bit about California, and just because I haven't looked at California recently, and my colleagues from California will have to. So I think California may be another pre-filing state. I'm just not certain. The only one I've really run into that was a problem was New York. And there's a technical reason for that, but because they actually don't file this. You're actually not registering the security, you're registering as a broker-dealer because of the nature of their laws. So they're different. Other questions? All right, well, I think we've beat this into the ground. So one of the things that I talked about was one of the things that the exemption is, there are two things the exemption doesn't get you out of. One is filing, and two is the fraud provisions. And you have to make sure the people that are buying the securities know what they're buying. And so what are the requirements? Actually, as a private placement, there's no, if you do 506 right, there's actually no technical obligation that says thou has to give X, Y, and Z. It's not like there's a proxy statement or S1 that says it. But there are typical things that you want to give people, and we typically give them a private placement memorandum that describes all these things. And the ones I'm going to, description of the business, that's pretty easy because usually you have a business plan or a description. So, your lawyer or whatever will look at it and to make sure you don't have words like, certainly we'll do this, we are unique, there's nobody like us, we're the best ever. Make sure there aren't words like that. Okay.
Do we have to do this for friends and family borrowers? I'm just raising $10,000, $20,000 from hitting up my relatives?
So the short answer is yes. It applies regardless of the amount that you're raising. I want to make sure that your investors know what they're buying. Having said that, it doesn't make economic sense to do it if you're raising $10,000 or $20,000. So what I typically do with those is a short form. So what I'll do is, while I won't do an entire private placement memorandum, which like 50 pages long, I'll make sure that some of these things are covered. So what I'll do is, for an example, a long-form subscription agreement. We talked about an agreement where the investor agrees to sign. I'll make sure that the exhibits are attached, so they know what the bylaws and articles and restrictions are, right? We'll make sure they have those. We'll make sure that they have the business plan. Risk factors, that I would do. They're pretty easy to do. So you do 2 pages of what can go wrong, and everything can go wrong. And you do these private placement memorandums, and there's 20 pages of risk factors that talk about everything that can go wrong. And if you actually read them, nobody would ever invest in anything ever again. But nobody reads them. But on the other hand, it's your insurance policy, because when something does go wrong, you can say, well, I told you that was going to happen, even though they didn't read it. It's a fiction, but it works. Okay, it's your insurance policy. So for those, I would do something that describes the business plan. Make sure, the one I have bulleted is conflicts of interest. I want to make sure that an investor knows the conflicts that the person who's putting it together has. How much compensation are they getting? How much, what kind of salary are they taking? What equity do they have? Because that's where the hot button issue is. When somebody invests in a company and it turns out that the founder's mother-in-law is taking a salary for not doing anything, that's the kind of thing that people are sorry they didn't hear about. Okay? So the point behind this is to make sure when somebody buys a security, we comply with the securities law, we make sure we file, make sure we do adequate disclosure. And you may say, well, why? That was very nice. Why? Well, in part because if you don't comply with this and you misrepresent to the investor, they actually have a right of rescission. They'll have a right somewhere down the line to let's just say, I'm out of here. I want my money back. And you won't have the money to pay them because you'll have spent it. That's a problem. Second, and this probably bothers me almost more, when investors, your later investors who are more sophisticated come in, they're going to look to see what you did, and they're going to make sure you complied with applicable laws. They're going to ask your lawyer to give a legal opinion that you've complied with applicable laws. And if you haven't done that, it's going to be a problem when you go to raise additional capital. People who have been here before have always heard me say that when we do this type of thing, there's two people I'm worried about, and I call them the little people on my shoulder. One is the next investor, and two is the buyer. Because I'm not, I mean, maybe you're just doing it for fun, but in large part you're looking for the big sale. I'm looking to build the business to acquire and sell it for a lot of money. If you haven't complied with these laws, it'll screw up your sale, and it's certainly going to screw up the next investor. So that's part of the reason you do it. One of the things we've seen recently is crowdfunding, and that's another way to raise capital, so I'll spend a moment on it. Let me tell you what it's not. It's not going out on Kickstarter and offering securities to people. It's a little misleading because people think it. It's not. If you go on there, you will see no stock being offered, no securities. We don't have that in our laws yet. It's proposed. It would be nice if we did. We'll get there. I have a little section on this, which I may or may not do, because it's not applicable yet. Hopefully it will be. Very soon we have the law, we'll have the regulations. We're waiting for the regulations. When they come, we'll spend a lot of time talking about how we can issue securities publicly to unaccredited investors. But right now, it's not the law. So what people do on the crowdfunding, so I sort of, as I'm old and stodgy, sort of went, all right, well, so much for the crowdfunding stuff. But it turns out it's actually really clever. And what Kickstarter does is allow you to go online, not sell a security, but raise capital offering non-security things, right? And so some of them are kind of cute, like one of my favorites I've used on here because I thought it was kind of funny was one for a restaurant in which in exchange for an interactive restaurant, whatever that is, and they raised $75,000. In exchange for a contribution, you got a fast pass, cooking class, tickets for dinner, tickets to the opening party, and my favorite, the 2014 Sexy Chef's Calendar, whatever that was. So you got that, and all in exchange for your contribution. Other examples is, this one's up there right now, Dobot Arm. For $339, you get the basic version of their robot, which is supposed to be used in your house. My point is, what's this really? This isn't raising capital. This is sales. This goes back to my very first point about raising money without giving up equity. What they're doing is raising a lot of money, promising to deliver down the road, using the proceeds presumably for the manufacturing costs or development costs, and eventually delivering the proceeds. So this is a clever way to get seed capital and basically pre-ordering products. It's not a bad idea. I think it's clever. Shell Games, a local company, raised $11,000 to become a member of their clubhouse. It's kind of cool. Here's another example I looked at the other day, Walter's Coffee Roastery. This caught me because anybody who enjoyed Breaking Bad, this is after that because it's a combination. It's inspired by the science and coffee, and for those amounts of money, you get those things, including a tote bag and a bag of coffee, and you get that for $30. You know, what did it cost the company to do this? You know, probably $1.50. So it raised $28.50. So far, it's raised $7,000, close to $8,000. 21 days to go. It's pre-selling, so it's kind of clever. Another way is to raise capital. But what it's not is selling securities. So I think I'm going to skip the. I think there's really no point in talking about the Jobs Act because it's not, that part of it's not applicable. Questions before I go on to talk about compliance, about the security one would offer? Yes.
So we have some funding in right now, and we're looking to recruit. So some of the applicants we've received are foreign nationals. So what happens if the H-1B process, right, it's under revision right now for OPT. Say you were to give equity to someone from China, and they joined your team, and then all of a sudden they didn't get their H-1B, and they had to leave. Now, there might be like some remote working solutions that could be sought out, but under worst case scenario, say a third of their equity vests, how do future investors view something like that?
And so putting aside the the visa issue. The more generic, if I'm getting the question, the more generic question is that I now have an employee who can't be employed by the company any longer. A third of his stock has vested, 2/3 is gone, but in the meanwhile I have a former employee who owns a third of the stock, right? And so that is that's a problem. So if it's a de minimis amount, nobody cares. But if it becomes a significant amount, then it goes back to my first point, which is you have a former employee, somebody who's no longer contributing to the company, owning a lot of the stock. And so you cured a lot of the problem by vesting it over time, so you only have a portion of it. So if somebody gets some stock up front, and you vest it over time, so for other people, so when you give employees stock, you vest it over maybe 3-4 years, so if they have to stay the whole time to get all the stock. So that's one, that you've already solved part of the problem in your basic setup, which is the right answer. I'll say there's a split of opinion on the second part. There's my view, for what it's worth, is the stock option plan or the equity arrangements with the employee should have a further provision that says when the employee leaves the company, you have a right to buy back their vested stock at the value at the time of the exit. And that way they will have gotten the benefit of the increase in value from the time they came in to the time they left. And so if the company doubled in value, they got the double value, they walked in, they contributed to that increased value, and they should get the benefit of that. What they should not get, in my view, is the increase beyond that because they weren't there to contribute to it. So what I don't love, and as I say, there's a split of opinion on this, what I don't love is employees wandering around buying lottery tickets and going from startup to startup to startup, thinking, okay, I got this one, now I got the next Google. I got this one, now I got the next for your favorite company. And because I need to take that equity, and it was only 100%, right? You can, if you give it more than 100%, then you are going to go to jail. So let's not do that. And there's a casino in Las Vegas that was built that way, but that's a different subject. But the point is that if I take it back, and let's suppose that I had a CEO that had 10% of the company, and he leaves. I'd like to take that 10% and hand it to the next CEO and allow him to have 10% of the company going forward, rather than have the former CEO get 10% of the company going forward. So that the answer is to have a repurchase price, a repurchase option when they leave at the fair market value at that time, so they get the benefit of the value on the increase in value while they're employed.
And that's for all employees?
Yes.
Okay.
Yeah. Now, there are people, I will tell you, that if I were to pick one provision that I've had the most discussion with people about, my clients, that's the one. Because they somehow feel it's inequitable. Because once it vests, it vests. They feel like this is an inalienable right, and people are entitled to it because they should get the upside there and after. My view is that's not the case, because I need to take that and give it to somebody else. They say, well, that's very nice, David, but I need that to attract talent, and that's part of what brings them on. Okay? So that's the counter. The market requires it. I'm not convinced that's the case. So there's a compromise. The compromise, okay, I get to buy back 50% of your vested stock. I mean, it doesn't have to be everything that vested. So there's compromises inside of that. Most of the time, so I win that argument with my clients, and they are very thankful that they had the provision in there later when they exercise it. And I will go you one step further. I have another client, the company, that had the right, did not exercise the right. Last year, or earlier this year, was in discussions with the VC. The VC was really irritated that there was so much of the company that was owned by former employees, and they passed on exercising the right. And they said, well, yeah, it was there, they just didn't do it. So it's something, it's a nice tool to have. All right? Question?
How do you value the company based on when you leave? Is there some sort of a provision you agree to an independent assessment, or how do you go about agreeing to what the company's worth?
The question is, how do you decide what the value is worth on the way out? And it's a good question. And I'll ask the reverse. How did you value it coming in? Because how you value it on the way in, that's probably how you should value it on the way out. And so if you're using appraisals, then you should probably consistently use appraisals. If you're using a formula, use a formula. So use the same methodology. Okay? And yeah. And it doesn't have to be the day they leave. I mean, typically you would do it as of the last valuation, the last reporting period, something like that. Other questions? I'm glad that was a good question. Yes?
In terms of the pre-sales you mentioned in order to gather capital, I was under the impression that there were certain rules preventing you from selling something that you didn't physically have in that way, say gaining capital and then building the thing later. Is that incorrect, or are there certain things to work around?
The question is, can you sell something you don't own? We haven't built yet.
Or, yeah.
Yeah, I haven't built yet. And I don't know of any reason you can't do that. As long as you disclose to people it's not built or it's not and it's at risk. But I can't. I never looked at the question, frankly. And maybe there's some consumer and there's lots and lots of consumer protection laws out there. So maybe there's something, but I don't know of any. Question. All right, so we talked a lot about the compliance with the laws, but we ought to spend a moment on what it is we're going to offer these folks that are nice enough to invest in our new company. And here's the pyramid of potential security or things you can sell them. And I'm going to spend a moment on it because it's probably, I like the way it stacks. Because it really goes from protection to non-protection. I mean, if you go into bankruptcy, which is really the ultimate risk, right, of a company, this is the stack of the people are secured in a bankruptcy or protection. So, for example, secured debt. That's the example of that is you borrow money to buy a house, a mortgage on your house. You would sign a loan and you mortgage it. That's security. If you went into bankruptcy, I don't care what other creditors you have, you didn't pay your credit cards, the mortgagee, the lender, would take the house, secured. They're at the top of the pyramid. So that's a pretty good place to be. Second is unsecured debt. So if you go into bankruptcy, you don't have any secured debt, the creditors will take their money, right? Share it on a pari passu basis. Let me go to the bottom of the bottom. Then there's equity. So what's left over is shared between the equity players, the owners, right? If I'm the company, if I own the company and I paid off the creditors, then I get what's left. There's a split. There's preferred equity, and we'll talk about preferred who may have a preference. So maybe take a step up above the equity, and we'll talk about a preference. And then there's the hybrid of the people who want the best of both worlds, so they'll be debt up front and convert to equity later. And we'll talk a little bit about that. So those are the possibilities to give people, and we'll talk about all of them. Some more than others. Debt, well, it's great. Debt's easy. It's the most straightforward. I got my new company, and I'm going to borrow money, right? It's great. It's very easy because I know exactly what I'm borrowing. I know exactly when I have to pay it back, usually with interest. It's kind of straightforward. It almost never happens, or rarely happens, in startup companies. Why? Well, first of all, if somebody's going to take a risk of the new business, they want the upside. I'm not just going to take it for the interest. I want some upside with this. Again, if you're going to be the new Google, I sure as heck want the upside of the Google or Uber or whatever it is. So it's not that typical, but it's possible. So most of the time, people want the upside, so straight debt doesn't always work. Part of the issue, I want to spend one moment on collateral, because if somebody takes debt, they will often want collateral, and usually that's in the form of either a personal guarantee or a security interest. And I got to spend one moment on the personal guarantee, because when you start a company, there are lots of opportunities to sign personal guarantees, and that's unfortunate. One of the benefits to our great system is that you can set up a company, corporation, and if you adhere to all the corporate formalities and everything else, which is kind of nice, then the assets that you put into the corporation are the only ones for which you're liable. I mean, they can't go reach in your pocket and get paid for it. So if I set up a company to be Widget Co., and Widget Co. sells some defective product and it blows up a building, the building owner can only sue, my company can't sue me personally because Widget Co. is the one that sold it, generally. An exception to that, and there's exceptions, but generally that is the case. It's a great, I mean, we absolutely ought to take care of that limited liability opportunity in startup companies, and that's why we talk about corporations, limited liability companies, and if you want to, you can come to another one of these presentations and we'll talk about which of those entities are best in the formation process. But the point is, we definitely want to do that. An exception to that, though, is personal guarantees. You screw up the whole thing if you sign a personal guarantee and say, if I don't pay, if the corporation doesn't pay, then I pay personally. So now I put my own personal assets on the line. So my point is that if you decide to raise capital through debt and somebody asks for personal guarantee, then you need to understand that if it's not paid, you've got to pay out of your own pocket, and they can sue you personally. Not as nearly as much fun. And there's hidden personal guarantees. Those are the ones I call, for example, your personal credit card. Lots of people, when they start companies, they use their own personal credit card. Guess what? That's a personal guarantee because you signed on that yourself. That's I call it a hidden personal guarantee. The one that I see most often is leases. When new companies go to start, they will often sign a lease, and the landlord will ask for a personal guarantee. Okay, just know that if you default on that lease, again, they can go to your personal account. So debt is possible. You can do it. They may ask for collateral. They may ask for a personal guarantee. The other thing about debt is people ask for a security interest in your assets. So if they have to foreclose, they get the first lien on the assets when they're sold. They get the money out of it. You know, in a startup company, that's typically not very valuable. I mean, what are you going to do with the assets? If you go bankrupt, there's not a whole lot there. But what it will screw up is your ability to raise capital, get other debt, like from banks. Because if you already given a first lien on your inventory or your accounts receivable, it won't be there for a bank. So I typically try to avoid that, and if I do have to give it, I agree to get the investor to agree to subordinate their interest to banks. Okay? So that's personal debt. Not that straight debt's not that common. Common equity, that's at the bottom of the chain we looked at. And the nice thing is that says, okay, I own 90% of the stock. You're going to get 10% of the stock. As an example, you give me $100,000. I'm going to give you 10%. And straight common. When I make money, you make money. When I get diluted, you get diluted. It's the most straightforward of the capital structures that we're going to talk about. It's typically because the common doesn't have some of the benefits or the privileges of the preferred that we're going to talk about. It's often valued a little less, so you won't get as good a valuation for common. And usually investors, angels, and venture capitalists want preferred and won't take common. So while it's nice, and I love it, and there's some angels that will because they say it eliminates some of the potential conflicts that come out of preferred stock and convertible debt. Most investors won't take common equity, but it's worth talking about. Question about common equity. And then there's preferred, which is, we'll spend a little bit of time on that because that's the most typical. And preferred stock and convertible debt are the two. Preferred stock is kind of nice, and what that says is, okay, I'm going to set certain preferences as preferred. And one is a liquidation preference, I'll spend a moment on. Two is a dividend. And as I say that, it's not the Disney kind of dividend. What that says is that if the investor puts in a certain amount of money, it will accrue dividends at a certain percentage over time, and it will be paid upon a liquidation event, which is a fancy way of saying a sale of the company. So upon a sale of the company, if it's an 8% dividend, it will continue to accrue, and they will get an additional, on top of everything else, dividend of that amount. So it's not like you're going to get nobody expects to get a check every month or a quarter or a year for the dividend. This is basically a way to increase the investor's return by increasing the amount of their investment, such as by the dividend, by 8% per year, or whatever percent you agree on. So it's a nice way to increase the return for the investor. And what that means, that's a fancy way of saying for the founder, it's additional dilution to you. And there's to be some control issues. The main difference between preferred and common, by the definition of the word preferred, is a preference. Upon liquidation, again, sale of the company, the preferred will get their investment out first. So if the investors put $2 million in and we sell the company, they'll get the first $2 million out. Straightforward as that. Now, there's two flavors of preference, participating preferred and non-participating preferred. And this sort of goes to make sure that you understand, if you're going to take people's money, what the result is, okay? Because this is a huge difference. Participating preferred means that the investor gets their money back, and after they get their money back, then they get their percentage of the company thereafter. So if they put in $2 million and they have 20% of the company, they'll get their $2 million, and they get 20% of the remainder of the company. Okay? Non-participating preferred means that they get the greater of their return on their investment or their percentage of the company. So if they put in $2 million, they'll get the greater, and we sell, they'll get the greater of the $2 million or 20% of the proceeds. The first one is an enhancement to the return. The second one is downside protection. Those are two different concepts. Let me give you an example. Here's an example that I did, that investment of $2 million. Sorry for the really clever way the columns are there. That was done purposely. And assume the $2 million investment, $3 million pre-money valuation, which means that the investors get 40% of the company, right? $2 million on $5 million total value, 20%, 40%, and 60%. Got it? Now, let's use participating preferred. That's the one where they get their investment back plus their percentage thereafter. So if we sold the company for only $2 million, then they would get their $2 million back. Game over, right? If they got the, there's a mistake there actually on the second one, but that's okay. On the $5 million, if we sell it for $5 million, they get their $2 million back plus 40% thereafter, so they get $3.2 million. And the founders only get $1.8 million. Now let me stop there for a minute, because this is really important. Notice there that we had a $3 million pre-money valuation. We said the company's worth $3 million. Investors put in $2 million. We say, you know what, this isn't really work. Let's sell the company. Now look what just happened. The investors got back $3.2 million, and the founders got $1.8 million. Just by virtue of this arrangement, the founders lost $1.2 million. Okay? Now, as you get higher in numbers, it doesn't matter as much, because if it's like $10 million, the founders get their 4.8, and the venture capitalists got 5.2. But the point is, it's a means to increase the value of the return to the investors. Now, compare it to non-participating. And the reason I said there was a mistake is because of that first one. If they if they invested $2 million, then they would get the first $2 million back, so that venture capital should get $2 million. That's a mistake. The $5 million, however, is right. They would get only 40% of the $5 million. They get $2 million. So look at that. That works just the way it should, which is if we sell it for $5 million on the regular participating, they get their greater of $2 million or 40%, which is still $2 million. So they put in $2 million on a $3 million pre-money valuation. That means post-money is worth $5 million. 40% is $2 million. Everybody goes back just the way they should, right? So it's an important distinction, and that's a part of negotiation. And there's lots of ways to negotiate around this. Sometimes you put caps on the return and that. But the important part for you guys, when you're starting a company and you're negotiating with either venture capitalists or angels, you want to make sure you know the difference and know what you're getting into. Questions about that? That's preferred stock. And then the most common on very early stage is convertible debt. And convertible debt is, for the investor, I'll say the best of both worlds perhaps, because what he says is, I don't know what the value of this is. You don't know what the value of this is. I'm going to lend you the money, but then I'm going to convert it to equity, probably at the next round of financing. So if I invest $2-3 million, whatever it is, when you raise real money later, maybe $500,000, whatever it is, when you raise real money from venture capitalists, my money is going to convert to the stock that they get, probably preferred stock, at a discount, maybe 20%, 30%, depending on when it happens. And the point is, and the deal is, I'm going to get a discount to the preferred because I put the money in earlier and I took risk, more risk. So I get a better deal. The good news is, you'll notice, I don't have to worry about valuation in that because I'm going to put off the valuation to another day. So rather than the angel and the founder arguing about what the valuation is, we're going to put that off to another day. And we don't even have to worry about all the rights of the preferred and the preference and argue about dividends and all that stuff. I'm putting that all off onto another day, and I'm saying I'm going to take, I as the investor, I'm going to get exactly what the real investors get, just at a better price. That's the most common way that people raise money at the very early stages. If you go to, for example, IW and others around town, that they're all structured that way. A couple caveats. Nowadays, people have gotten a little more sophisticated about this because they worry that the next round may not be as smart as they'd hoped. And so they'll put a cap on that valuation. They'll say, okay, I'll do it to a discount, but you know what? I'm going to put a cap of, call it $5 million, $6 million, whatever it is on the valuation of the next round, so it can't go above that cap. My argument is, okay, then let's put a minimum, and I never win that argument. But the point is, they will typically want a cap, so you just have to argue about that. But it's the most common, and it's actually pretty easy to document. And you don't have to worry about articles and preferred and all that stuff. So it's actually the easiest one to document. Yes, question? No? Cool. Just, yes? Excuse me.
So isn't the previous one bad for the venture capitalist though, because the next time when the venture capitalist is putting in money, they don't have the stock at the same price as the earlier person who gave the convertible debt?
So the question is, isn't that bad for the venture capitalists because essentially they're getting a worse deal than the convertible debt folks are, who are converting it at a lower valuation? That's a fair point. But let me look at it the other way. If the angels had come in at a lower valuation, they would have done that earlier anyway. In other words, they would have come in at a valuation that they would already be on the cap chart at a lower valuation. So they would have already gotten a better deal. So I'm not sure you're right that the venture capitalist cares because stock is going to somebody else, and they care how much. They're really looking at how much is left for the next round. But I'm not sure the venture capitalists care that much that they're getting a better deal because they came in earlier and took more risk. Also, I will say that it's not as uncommon as angels would like that they do come back and negotiate that. And actually, this morning I was on a call in which we were negotiating exactly that, which is that the venture capitalist is saying that I don't want you to have your discount. And I don't want you to have your interest that's converting because the cap table can't handle it. And I think they're going to negotiate a half of the discount that they had originally negotiated for. So it's a good point. Yes? Now I'll come back to you.
So obviously, once you get to the venture capital stage, if you get convertible debt from an angel investor, you're going to have to disclose that you have that convertible debt so they understand what the conversion terms are. But you're able to not disclose what the valuation cap is, correct? Because otherwise, if they found out what your valuation cap is, then you've essentially gotten rid of your advantage of doing convertible debt and not talking about valuation in the first place.
So the question is, if you put the cap in, and will that impact the discussion on the VC round in some way? Because I have two responses. One is, and your other point was, have you gotten away from the valuation question by virtue of negotiating the cap? And the latter is, you're absolutely right. it does mitigate the benefit because you'd end up having a valuation discussion in order to establish the cap. So that is absolutely right. That's one of the reasons I argue on behalf of the company that we shouldn't be having, that was the whole benefit of not having this in the first place. And, maybe 2% of the time that argument wins. But because they want the cap. And you can even establish it pretty high. They just want to make sure there's no schlemiel out there who really comes in at some crazy number that converts it. So usually you can get a pretty high cap. As to the impact it has on the next round, my experience is that it's a new round and people don't pay much attention to the pricing of the last round, particularly angels, and the cap. I think that typically is not in the VCs are valuing it on their own basis about what return they can get and pay less attention to the valuation of the first round. Now they're going to pay attention to the impact it has on the cap chart and what's left for the founders and the employees and what kind of option pool there is, et cetera, but they care less about what price it was. Although they certainly don't want to be a lower price, or a significantly lower price, but they don't care as much about the pricing. Sir?
So in the example from this morning, what might the holder of the convertible debt get in exchange for less of a discount? And then also, could you just talk about redeemable versus non-redeemable preferred stock and seller financing?
And what?
Seller financing.
Seller financing. Okay, there's a lot. So that's good. The first question was, so what was the first part? What was it doing again?
What did this guy get in exchange for reducing his discount?
So what did he get in exchange for reducing the discount? He got the pleasure of the VC coming in. The place he's in is the VC says either you take the haircut or I'm not going to invest. And the angel has to sort of sit there and say, well, let's see, I'm going to let this company is going to go nowhere, or I'm going to have to take the discount. So he doesn't get much for it. And maybe he might try to get a warrant for it, but it's not going to happen. I mean, it's basically take it or leave it. And they know that going in to some extent. Your second question was?
Redeemable versus non-redeemable?
Redeemable versus non-redeemable stock, preferred stock typically. And so redeemable stock means that, and it could be on two counts, right? One is the company having the right to redeem the stock, and two is the venture capitalist having a right to cause the company to redeem the stock. It can be either direction. The latter is the more typical one, which is when venture capitalists come in, or investors, they want to know that they're going to get out of this thing somehow. I mean, this is nice, but you may start a company, you may decide, hey, I kind of like this. I'm just going to keep operating. I got a nice salary. It becomes, quote, that word that nobody likes to hear, a lifestyle company, right? You're just going to run it and run it and run it. And so the venture capitalist says, I want some way to get out of this at some point. Sometimes they negotiate a right to a redemption right, which is a fancy way of saying I can cause the company to buy me out, and it would be at the value at that time, or the greater of the value at the time, or the amount I invested plus the dividend. And what that's really doing is causing the company to be put up for sale, or at least talk about it being put up for sale, because the company won't be able to afford to take them out at that time without refinancing it. So it's really an opportunity to talk about it. And I resist that on behalf of the company, and I say, look, I can't put myself into that because it's going to be a real problem for raising money down the road, because other people aren't going to put money in if there's this redemption right. And sometimes you win that, sometimes you don't. But that's from the investor side. There's also sometimes people want it from the company side. I want a redemption right. I want to be able to take the investors out at some point. That's in my experience, that's fairly atypical. Because, again, the venture capitalist investor will say, well, I don't want that. Go back to my employee thing. I want the upside. And I don't want you to be able to take away the upside. And so I don't want you to be able to take me out. So typically, the company can't get a redemption right, and often the company does. The investor gets a redemption right.
So when the company, investor is getting the redemption right, you would call that which? Redeemable?
Right.
Preferred stock?
Yes. Yep. And you asked about seller financing, and what kind of seller financing?
I don't know. What is it? Everything about it.
So seller financing means that if I acquire an asset, the seller will take back paper, and so they'll essentially lend me some money to buy it. So I pay it over time. So seller financing means, for example, if you buy if you decide I love that technology, and so in order to grow this company, I'm going to buy that technology for company A, and rather than, sometimes I give them stock for it. It's a wonderful way to do it, but they won't take my stock. I can't imagine why. So I'm going to give them cash plus a note, and the note is seller financing. And that's okay. There's nothing wrong with that. And that's not uncommon. Part of the problem, though, is questions regarding security and making sure it doesn't screw up your bank financing and all that stuff, but that's not uncommon. It's actually a nice way to finance stuff, because if a seller really wants to sell, get them to take back some paper. The places, if they have a lot of debt that has to be paid off, then that's sometimes a problem.
So that would also be a way to make sure the seller retains an incentive to help maybe run the business so that cash flows can...
Yes. Yes. So the question is, does that help give the seller incentive to cause the company to succeed in the future? And sometimes you do that with seller financing, but that's fairly egregious, because you're at the bottom of the list, which is to say, I don't want to bankrupt the company in order to sell it. So the way you typically deal with that, if your objective is to cause the seller to want to cause the company to prosper, you'll usually do an earn-out, which is say, I'll pay you X, and then I'll pay you a percentage of something going forward. If we hit certain milestones, percentage of revenue, percentage of EBITDA, something, an earn-out going forward. And that causes them to have more of an incentive to participate. Okay, you had a question.
Yeah, how do you find that C investors respond to convertible notes? I mean, like individual investors. It would appear that there's been a ton more risk on a seed round than there is on a VC side, yet I'm only able to buy at an 80% discount. And, I can understand that IW has, economic development incentives to give money out, but it's not necessarily, their money that it's not Rich Lunarek's money that's being invested, it's the public money.
Right. So the question, I think, is what is the typical non-IW kind of angel investors' perception of convertible debt, and why do they want to do it? Because there's more risk associated at that point. The reason, and it's interesting you should say that, because I've seen a trend over the last few years in which, putting aside friends and family, angel groups have moved more and more toward priced rounds and preferred than convertible debt. So to your point, I've seen, and I think if you look at most like Blue Tree and other more sophisticated angels, they've moved away from the convertible debt and closer to the price round for exactly the reason you're articulating. It's really best on quick, low amounts where you think you're going to flip it fairly quick. In other words, it's not going to be a long time. It's not going to be years. It's going to be a fairly short period of time, and so you're trying to get it quickly. If you're going to flip it and get the VC route and get the preference with them, so for example, to the other point, if you go in early as an angel and you take common stock or even preferred stock, and you do a priced round, when the preferred comes in, they're going to be above you, right? They're going to have a preference above you, who probably have better terms than you have. If you come in as an angel and convert to them, a convertible debt, you'll actually be on pari passu with them. So the terms actually, although the pricing may not be great, but a discount, but you're also going to have the economic terms that they got, the place, what I call it, on the preference and dividends and all that stuff. You're going to get all those benefits as well. So it's a balance. And by the way, the other point is that on the early part, you're a debt structure. So if it goes bust, you're at the top of the structure. He's going, what good does that do me? And not a whole hell of a lot, but it gives you something. Okay? And yeah, IW would disagree with your characterization. Yes, go ahead.
So, I understand, the point of the cap on the capital is so that when the next round of financing comes in, the previous investor want his value to be of a certain percentage or more. So, is there a way to, instead of capping the valuation, you cap the amount of percentage he gets? So, he get no less than 10% of the company, regardless of the next valuation, instead of capping the valuation?
The question is, can you cap the percentage they get rather than the valuation? In essence, if you think about it, if you cap the valuation, you've actually capped the percentage. Which is to say, if they put in $1 million and you cap it at $5 million, you've said it can't go below 20%, right?
Like, if they raise like $10 million instead, you still get a 20%. Instead of like, otherwise you wouldn't be able to raise $10 million.
So let me think about that for a second. If they raise $10 million, they would get the same percentage.
Yeah, so which changes the discount rate.
Yeah. So why would I want? It's really about the pre-money valuation, not the amount they raise. So I mean, as the company, I don't want to give somebody basically anti-dilution protection for the amount that they raise. In other words, why should the person end up with? Let me argue back at you. If they raise $5 million or $50 million, why should the angel end up with exactly the same percentage? Because really, if somebody puts $50 million in, they're bringing $50 million of value. And so that shouldn't be the determinant. How much they raise shouldn't be the determination of what percentage they get, right? It should be the valuation at the time. Does that make sense?
So like, I guess like the reason why I ask is like, maybe the previous investor wants his percentage in the company, but he doesn't want to stop the growth of the valuation of the company, so he might want this instead.
Yeah, and that's what I get it, and that's in essence what the cap on the valuation is supposed to get to. I mean, yours is another way. I mean, to go to your point, some people will negotiate anti-dilution protection, and that's a euphemism for two different protections. One is price protection, which is if somebody invests in a lower price, they want protected for that, and there's different versions of that, and we won't get into that. But another one is I want my percentage. I want if I got 5%, I want my 5% up to a certain amount of capital raise. As an example, if you license from Carnegie Mellon University, whoever heard of that? If you license, their deal is they think they get 5% and up to a certain percentage of capital that they raise, and it's essentially non-dilutive till you get there. And that's sort of that's a way to accomplish the same thing. 8 minutes. I've been known to talk fast. I'm not going to talk that fast. Other questions, because it's more important that we answer questions and sort of hit the stuff. Yeah. I'm going to, one other thing, I'm going to skip the examples, and actually I'll wrap. Yeah. So I'll do this in a second, but the fact convertible debt, the fact that just be aware that too much convertible debt can be a real problem, because if you try to convert too much of it, you can lose your company because you don't know what the valuation is. So if it converts at a low value later, and you have too much debt, the math is terrible. So just beware of raising too. We had one company that raised $9 million in debt. I can tell you it's too much. Convertible debt. Control issues. When you bring in investors, one of the things that people always ask about is control, and so you ought to spend a moment thinking about that. How much control am I going to give up? I call it 3 layers of influence, because I always say I want influence. There's the control that says I can cause you to do something. There's the control that says I need approval over it. And there's approval that says, I just want to be consulted. I'm only pointing that out there. We can talk about different versions of it. But when you're raising capital and you're talking to investors, think hard about which of those layers of influence are they seeking. And it's really important, because if you give somebody it early, some of those, it can come to harm you later. I'd give the example of a company that I would not represent, gave a right to veto a sale of the company. Many years later, they went to sell the company. Everybody wanted to sell. This investor didn't want to sell the company. That was a problem. They ended up handing over a whole lot of money to that person who wasn't entitled to it strictly under the proceeds, but essentially to get them to go along with it because they had a veto right. So they had to buy out the veto right, and I'm talking about for several $1 million. So be careful what you give up in that equation. So top 10 mistakes. And these are not as funny as one would hope they would be. Overpromise, under-deliver. When you do your PPM, when you're giving private placement, when you're talking to investors, just be careful about what you tell them and be honest. Don't create the hockey stick projections and have a basis for it. waste early money. This is probably the one I see most common, which is that when you raise, the early money is the most expensive money. And so really, and so you get a check and you start spending it. Really think hard before you to buy it, about taking people's money, about what you're going to spend it on. Are you going to spend it on, if you're going to do a prototype, can you do the prototype on a cheaper way? So if you have to pivot the company, do it. I can't even see the damn thing. Oh, disrespect capital. This is, you know, people are putting in real money. And you know, they worked hard for that money. Usually it's after-tax dollars. I mean, it's real money. Everybody knows it's risky. It's part of the game. This is not a surefire. You're not putting the money into IBM or otherwise. But what people do want to feel is they're being respected, that you communicate with them. If there's a problem, you tell them there's a problem. If things aren't going to go well, you tell them that. And they will be a lot more understanding and a lot more patient. And frankly, they'll put in money to help you solve the problem if you're upfront and honest with them and respect them. Target old ladies. This is what I call the Thanksgiving Day problem. If you take money from people who can afford to take it, to give it. And I always joke about if you take somebody's money, a family member, and can you go to Thanksgiving dinner with them, and having lost their money, and they'll still sit there and smile at you, or at least come to dinner, right? I mean, so the point is, they may be unaccredited, they may be accredited. Make sure they can really afford it and they understand the investment. Poison the company, I sort of got to. I'm going to skip that. Yeah, I'll skip that. Leave the numbers. I want to spend one moment on this. The cap chart is really the sale price. When you go to the store and you buy a widget, you give them cash, and you sure as hell know how much I'm giving them and when I'm going to pay it and all that stuff. Well, when you're giving people security, you're giving them equity. You're selling equity. It's really important to understand this. So don't leave the cap chart to somebody else. As I joke, the lawyers in the room, I know you went to law school because you didn't want to do math. Get over it. You have to do this. You have to do this Excel spreadsheets, and you got to do it. For the business people in the room, don't leave it to the lawyers. You got to look at the cap charts, understand every bit of it, and go through what ifs. I will go you one step further. If your lawyer allows you to take money without doing an Excel spreadsheet for you, showing you the implications, shame on them. Someday I have to figure out how to do it, but I've heard this pretty good. Just joking. I'm going to skip that. We talked about that. And I'll go to the last one, which is, I love Edgar Snyder. I think Edgar Snyder is my hero. He has brought legal services to people who otherwise wouldn't get it. He is absolutely my hero. I would not hire him to start a company because he's never done one. So don't hire your crazy uncle in the corner, who happens to do estate work. Don't hire a personal injury lawyer. Hire somebody who does this for a living. There's lots of traps for the wary. I'm not saying me. I don't care. Just make sure you're dealing with a lawyer that actually understands this stuff. Questions? I have 30 seconds to go. Okay, cool. Then, if you have any questions, feel free to be in touch with me, and thank you very much.
Just so you know, this is Raising Capital Part 1. So this is where you learn the basic terminology, but we have, in our future Start Smart coming up, it's called Raising Capital Part 2. And this is one of the fun ones where we're going to, we have two lawyers, K&L Gates, in the room. We're going to divide the room. Half of you are going to be the startup company, the other half are going to be the VCs, and you're going to negotiate a term sheet. And literally, half the team goes out of the other room, decides what we want to have, the other half decides what they're going to give. They come back, and then we role play. And it's a lot of fun. You learn a lot. And Henry is, think of a K&L Gates with the ponytail. You just don't see that ordinarily. So it's great theater. Yeah. It's going to be in the spring. So we have another one that will be coming up in the spring called Business Formation. So you're going to be a C Corp, S Corp, LLC. So just keep an eye, sign up for the weekly bulletin where we publicize all these about when they're coming up. Any other future connects, any talent looking for projects looking for talent, or any last words for the cause? Thank you for coming.
I asked Sari if they were going to do that. She's coordinating these, or our end of it. At the very beginning, they were.
I had a quick question. So if you happen to be like an employee, like a full-time typical staff of, let's say, university or whatever, company, and you develop in your own time a product using your skill but unrelated to whatever it is you're working on, and then you use that to start as an asset to a company. What are the legal